Welcome to the NCDWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle, and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 256 of the NCDWI Guy podcast. It has been a few weeks since I have recorded, and that is because I lost a great role model, a great man in my life. My father-in-law died at the beginning of June, and was an incredible human being, incredible husband and father, great business person, amazing mentor to me. I'm going to do a podcast episode specifically on the business lessons that I learned from Dennis here in the next few weeks. But that has been the reason for my absence, and I am excited to dive back in and finish the Dojo series that I had started a few months back. This will be part 5 and the final part of the Dojo series, and that is the place of the way. The place of the way is what Dojo means, and the ultimate place of the way for the criminal defense lawyer in North Carolina is the courtroom, and specifically the trial. So we're going to start this episode off with one of my favorite poems, quotes, speeches, whatever you want to call it, from Theodore Roosevelt, the man in the arena. It is not the critic who counts, not the man who points out how the strong man stumbles or where the doer of deeds could have done them better. Credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes short again and again, because there is no effort without error and shortcoming, but who does actually strive to do the deeds, who knows great enthusiasms, the great devotions, who spends himself in a worthy cause, who at the best knows in the end the triumph of high achievement, and who at the worst, if he fails, at least fails while daring greatly, so that his place shall never be with those cold and timid souls who neither know victory nor defeat. As I was reading through that and thinking through the absolute punch in the face that those words provide, I literally got like chills on my arms. I mean, that is just such a amazing thought, such an amazing speech from Theodore Roosevelt when applied to the courtroom. Because if there is one thing that I would tell any lawyer trying to become better in trial, it is to get into the courtroom and try cases. Yes, you want to put in the prep. Yes, you want to know the facts backward and forward. Yes, you want to research the law, go to CLEs. Yes, you want to bounce the case off of other lawyers. Yes, you want to go in the courtroom and watch other lawyers that are great trial attorneys do it themselves, so that you can find takeaways that you can bring into battle with you. But at the end of the day, the goal, if you want to become a trial lawyer, is to try a ridiculous amount of cases. And I have been going through this kind of interesting space on my end, because just like math, retaining a language, retaining most skills, if you stop trying cases, you will lose the skills of being a trial lawyer. And I had somewhat stepped away from the courtroom for a period of time to kind of focus on managing the business. And that is still going to be like a focal point on my end within the firm. But I'm back in the courtroom on a more regular basis. I'm back trying cases on a more regular basis. And I have found it both amazing and frustrating. And the reason it's been amazing is because I love being in front of a judge arguing a case. I love fighting for my clients. I love standing up and going to war on behalf of a client. The reason it's been frustrating is because I'll admit I'm rusty. I'm rusty. When you're doing this day in, day out, you're fighting day in, day out, and especially when you're kind of doing it in a different jurisdiction with so many things being new, I feel a little bit out of my element. I feel a little bit of a novice mindset when it comes to trying cases. I feel a little bit nervous about it. And I've tried a lot of DWI cases, and there are times when I have felt, I would say almost every case, you feel some level of nerves as the case is getting ready to be called or as the DA is asking you how your client pleads. But when you've been out of the courtroom for an extended period of time and then you step back in, there's a certain swagger that is lost, a certain confidence that is lost, again, especially where you're in a new jurisdiction. So for any young lawyers out there that are thinking, oh man, Jake, you've tried a bunch of DWI cases. You can't possibly remember what it was like to kind of step in the courtroom. I'm just going to tell you, I'm kind of there with you right now. If you're feeling like you're out of your league, like you need more experience, I'm there with you. And the only way to do it, and I know this part of it from experience, is to try a lot of cases, to try cases frequently. As Roosevelt says, who erred? You've got to make mistakes. Who errs? Who comes short again and again? Because there is no effort without error and shortcoming. You're going to fail. That's just the reality of it. I've said many times on this podcast, one of the favorite quotes that I ever heard in the DWI lawyer context was from a experienced trial lawyer at a CLE in Georgia who said, "You're not a real lawyer until you've lost 10 in a row." You're not a real DWI lawyer until you've lost 10 in a row. And that is absolutely the case. Absolutely true. You have to lose a lot. You have to make a lot of mistakes. You have to do it badly a lot of times and frequently in order to become a trial warrior. That's the only way. It is the way. Again, this is the Dojo series. This is the place of the way. If you want to be a trial lawyer, you got to try a lot of cases. Plain and simple. Easier said than done, but plain and simple. Couple of just, stats that I would say kind of support this in some way. The average NBA player plays about 394 games in their career. I think it was based on 4.8 seasons, about 394 games over the course of their career. LeBron James has to date played 1,562 games. Basically 4 times what the average player has played, and he's not done yet. And again, LeBron may not be what he used to be physically, but the amount of mental data that he has collected through those minutes on the court, I think I looked it up, and he's played somewhere just north of 59,000 minutes of basketball in the NBA. The amount of wisdom, the amount of understanding of the game, the data that he has collected and synthesized is unbelievable, unmatched. And you only get there through doing it repeatedly, getting back in, win or loss, collecting that information about how to play the game better. Similarly, in the NFL, average number of games played by average NFL players, 56. Okay, that's not like a set number, but basically like 3.5 seasons is kind of like the normal time. People are missing a couple of games due to injury, whatever it might be. Average, according to Google, games played by an NFL player is around 56. Tom Brady played 335 games. So basically, near 6 times what the average player is playing. And again, from day one, you're just learning so much about the game. You're learning so much in your first year, in your first couple years. I mean, just constantly collecting and synthesizing data, becoming somewhat of a automatic response in certain game situations based on all of that past know-how. This is what a great trial lawyer can do. And a great trial lawyer can do this because a great trial lawyer has done it so many times in the past, so many dang times. Building up on that constant, just the amount of volume, the sheer volume of cases that you try are going to build on themselves. It's going to create that compound interest of knowledge in the courtroom. Confidence. Confidence comes from doing it first and then winning later. Confidence comes from doing it first and then winning later. I would say that the reason that most lawyers don't want to take a case to trial isn't always because they have like a bad case or a bad case for trial. They just don't want to make a fool of themselves in the courtroom. So even where they have the winning lottery ticket, even where they have a winning case, they don't push it to trial because confidence doesn't come from winning in the early stages of things. Confidence comes from trying it. Confidence is built from taking the case to trial and realizing, hey, that wasn't so bad. Hey, that wasn't so complicated. Hey, I made this mistake. I won't do that next time. Hey, that wasn't as hard as I expected it to be. Or, hey, I didn't prepare enough for that case. I need to put more time in. I just got my ass handed to me by the state. I don't want to do that again. I'm gonna double down and sink my teeth into this stuff and make sure that doesn't happen the next time I'm in the courtroom. Are you ready for trial? No is often the answer. No. Do it anyway. Are you ready for trial? No. Doesn't matter. Go for it. Push the case to trial. If you want to be a great trial lawyer, you've got to try cases. So I'm going to give a couple of thoughts to you about the trial mindset, the dojo trial mindset, because this is the courtroom. The courtroom is the place of the way. I mean, this is the ultimate place of the way for the criminal defense lawyer. The place is the courtroom. So, got to get comfortable in the courtroom. You got to feel confident, bring swagger, get your butt handed to you. All of it. All of it happens in that beautiful space, whether it's the most ornate courtroom in the state or basically a municipal building that's being temporarily turned into a courtroom because the courthouse is closed, as is the case in Madison County right now. It's not even a courtroom. It's an ag center that they're running court out of right now. Doesn't matter. That's the place of the way. That's where the magic happens. That's where the criminal defense warrior lives. So before I dive into these points, I want to remind everybody that we have our Freedom Fighters CLE coming up on July 18th. And I want to give you guys a special offer to come and join us at the Freedom Fighters CLE in July. July 18th, we're going to be at the Charlotte Knights Stadium talking through negotiation and sentencing in criminal and traffic cases. Unbelievable lineup of speakers. Go to freedomfighters.law, and under the events tab, you will see that upcoming event for the CLE in Charlotte. It's going to be an epic setting. It's going to be an epic day of learning, epic networking opportunity. We're going to go to a baseball game at the end of the CLE. It's going to be unbelievable opportunity. And if you sign up here over the 4th of July weekend, it's the Freedom Fighters. We're all about freedom, independence, baby. If you sign up here over the 4th of July weekend, so from the 4th to the 6th, ticket will be half off. Your cost of CLE will be reduced to 50% of normal pricing here over this coming weekend. Just go to freedomfighters.law and use the promo code for July. The number 4, JULY, all lowercase. For July is the promo code for that 50% off discount. So, to dive into a few thoughts again about the courtroom, the place of the way for the criminal defense lawyer. If you want to feel confident about your case, I think one thing that is very helpful is to sit down and truly assess what your client has to lose or gain by going to trial. So many times when we're thinking about taking a case to trial, we immediately think, am I going to be able to win this case? Is this a good case to try? Do I have the facts to support my position? What am I going to look like a fool, or do I have a good argument? And while that's important, I'm not going to say that's totally should be outside of the realm of consideration. Sit down instead and think about what your client has to lose or gain by going to trial. And this may lead you and your client to be more in the plea camp post consideration, or more in the trial camp post consideration. So, what are some of the considerations? Time and travel. Okay, if you have a client that lives in Hawaii, they were back in North Carolina visiting a family member for a wedding. They went to a wedding and now they're back in Hawaii. Maybe the time and travel consideration, thousands of dollars in a plane ticket, cost, travel time, doesn't make sense given the impact this is going to have on employment, criminal history. It could be somebody that's retired. Maybe they would prefer, if it's an option, to do a plea by waiver and basically say, look, I don't care what good attack points that we have. If you can save me from having to come back to North Carolina, let's roll with it, because I don't want to spend the energy, time. I don't want to have the anxiety of being in the courtroom and going through a trial. I don't want to have the video played and be in front of the judge staring at me as I'm acting a fool on video. I just don't want to deal with any of that, right? So, time and travel. What are going to be some of the impact? Jail time. Sometimes I think this is a great way to feel confident about going to trial. On most first DWI offenses, no kid in the car, no accident, how much do you actually stand to lose if you take a case to trial? If your client is facing a level 4 or 5 if they plea, or a level 4 or 5 if they take the case to trial, what's the difference? Think about what you're actually risking, what your client has on the line if the case goes to trial or not. Felonies make me nervous. It's like anytime we have a habitual DWI case, it makes me nervous because it's like, well, this person is looking at a lot of time. And in reality, it's kind of like, well, yeah, maybe that's a good reason to push the case to trial, because felony sentencing is so structured, especially when it comes to a habitual DWI case. How much does your client actually stand to lose based on what, if any, plea offer your client has been given by the state versus what they would, be looking at if they took the case to trial and were convicted without the plea offer? A lot of times it may be pretty limited impact between those two things. So you have to assess what your client stands to lose or gain. Educational and job opportunities. Is my client's scholarship going to be lost if they're convicted? Well, maybe it doesn't matter then what the, attack points are on the case. Like, let's see if we can save this kid's scholarship. Maybe a job opportunity is going to be lost. Driving is required for my client's work. They've got a CDL. They work for a delivery company. They're a traveling salesperson. They lose their job. They lose their ability to drive a company car. Their job is out the window. You have to think through what the impact is going to be on those education and job opportunities. License. How is this going to impact your client's driver's license and their ability to get, around for their kids, family, job, all of those things? Immigration. Regardless of what the evidence is against your client, what the law looks like, if your client is going to be deported, or at least faces a high chance of deportation if they're convicted, that may be enough in and of itself to take the case to trial, regardless of what the facts and the law say. So if you want to feel good about taking a case to trial, you don't have to feel good about the facts of the case. You want to think about what your client stands to lose or gain if they take the case to trial. Are they facing a more serious punishment? Are they looking at higher jail time if they take the case to trial? Are they looking at no difference if they take the case to trial? Are they looking at significant consequences if they plead guilty and a not guilty is the only thing that is going to save the day? Assess what the potential loss and gain is, and you'll take a lot of pressure off yourself in terms of taking bad cases factually to trial, which I think is what prevents a lot of lawyers from trying cases. They think, I'm going to look silly doing this. Who cares? Nobody cares. You got to get over yourself. We all want to look pulled together. We all want to look like we're winners. And that's just not the reality sometimes. Sometimes you got to try tough cases. Sometimes you got to try bad cases. And that's okay. Nobody is going to say anything bad about you afterwards. It's like you're doing your job. That's what you're supposed to do. The person that is responsible for getting a W at trial is the state. They're the only person that has the ability to decide whether or not the case gets tried, ultimately, because your client doesn't have the ability to make the case just go away, typically to settle it. There's generally no negotiation that's being offered, and there's typically no significant plea deal that's getting offered on a DWI. So it's literally 100% in the state's hands. If they are saying, well, I didn't offer you anything, and we're going to take this case to trial, it's on them. It's not on the defense. Don't take on that weight. They're the ones calling the case for trial, not you. They have the ability to dismiss it. They have the ability to get rid of it. Take that pressure off yourself. Don't be afraid to try a case where no issue exists. This is like kind of related, but point number 2, again, it's the state's burden. But don't be afraid to try a case where no issue exists. I have shared this several times on the podcast, but I can remember a client that I had we had what I thought was an amazing reasonable suspicion argument. My client is driving down the road, passes a police vehicle headed in the opposite direction at a high rate of speed. He's flying. High rate of speed. The deputy whips around after my client passes him, doesn't have an opportunity to catch the license plate, doesn't have the ability to say much about like the color, make, or model of the vehicle, whips around and starts pursuing my client in the direction he was traveling. My client turns down a side road. Deputy loses him for a couple of minutes and then finds a car parked on the side of the road that has just turned off and sees a person walking into the house. And that's the basis for the stop. He pulls up behind, turns on blue lights, basically detains him, says, "Hey, why are you running away from me?" The client says, "I wasn't." So I think we have this great reasonable suspicion argument, like very difficult to kind of figure out whether or not this is the same person or not. So anyways, we put this case up for motion to suppress. The judge, here's all the evidence. We had a solid judge for this issue. Judge hears all the evidence, basically considers everything and says, "I think there's enough to create a stop." I also challenged PC. That wasn't as good of an issue. Denies PC. And so we basically are getting near 5 o'clock. Case gets continued, which didn't like routinely happen normally, just like straight into trial or plea. But case gets continued. I tell my client after court, "Hey, look, when we come back, you blew." I can't remember what it was, but it was a 0.14, I think, somewhere in that range. I'm like, "District court, we're not gonna win this case. Like, we had these good arguments. They were real." And my client says, "Let me think about it." We come back a couple months later. We've talked a couple of times in between. And ultimately he's like, "Hey, I'm feeling lucky. Let's give it a whirl." And I was like, "Why are we wasting the court's time? This is so stupid. Why are you like, you're going to make me look silly? I have nothing to offer. Like, I literally don't have any questions there's no way for me that I can see to attack the breath test being introduced. Like, this is going to be silly. Like, I don't have anything else to say." So ultimately, we come back, limited additional evidence is presented at trial. We plead not guilty. State asks pretty limited questions. I don't really have a lot to object to on cross-examination. And ultimately, kind of like pointing to the fact that, "Hey, Your Honor, my client, looked pretty normal on field sobriety. If you look at that compared to the, number," like I just kind of went down this. I don't remember exactly what I said, but it was effectively like, he didn't act impaired. The state hasn't proven its case beyond a reasonable doubt. It was more articulate than that, but at the same time, not a lot more substance than that. And, I'm just waiting. I've got like my LDP ready to go. I've got the assessment, treatment, all this. And so finally, the judge is issuing his ruling, and he basically says, "Well, I think that the state had enough based on the initial stop that was argued a couple months before to create a stop, but I don't think that there was enough evidence to prove that this was the same person that was driving earlier, and there's been no real evidence of driving. He exited the car, so there's not beyond a reasonable doubt enough evidence to connect this person with the person that was on the roadway earlier." And it was like, well, that was the whole basis of the original stop. Again, it was floored. The DA was floored. I was floored. The judge found my client not guilty. And the DA literally was like, just looking like just totally bewildered. And I was trying to like hide my, utter shock and surprise and act like, "Oh yeah, I saw this coming." That you try to have that confidence in the courtroom. Went back into the DA's office afterwards, and the DA was like, "What the heck just happened? What was that? And I was, honestly, like, I have no freaking idea. I don't know what just happened. That was, yeah, totally out of left field and sucks for you because we just got not guilty. So, but that is the reason that you want to take bad cases to trial, because if that client had listened to me as the lawyer being like, there's no way we'll ever win this case, you're going to be convicted, blah, 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 he would have, to this day, a conviction on his driving record, a conviction in his criminal record. He would have that for life in North Carolina. And instead, that thing does not show up. It is expunged. It is gone. It doesn't exist. And it was because he held my feet to the fire and was like, I want to try my case. Okay, we'll do it, But I've seen that and heard that same story from other lawyers where there's plenty of cases that I have lost that I felt like the law was on my side, that I felt like were great cases to try, that I couldn't believe a judge or a jury returned a verdict of guilty. And equally, there are times when it's like, I just don't see how we would possibly end up with a not guilty or with this charge being dismissed. And then something interesting happens. The officer is terrible on the stand. The paper discovery looks great, but the officer can't meaningfully articulate impairment, how to do field sobriety tests, isn't trained in the field sobriety test. Everything that looked so good on paper just unravels. There can be all kinds of last minute things where a necessary witness doesn't show up at the courthouse, sometimes even in like almost real time. It's like, oh, we thought we had this person and now they're not here. There's so many things that can happen with a case. So don't be afraid to try a case where no issue exists. Again, the worst that can happen a lot of times is that your client is going to be convicted, which is what's going to happen if they don't try the case. They will be convicted by a plea. That Wayne Gretzky quote, you miss 100% of the shots you don't take, absolutely applies. Maybe you actually miss 99 of the 100 shots that you do take, but you still have that one shot that goes in. Don't be afraid to try a case where no issue exists. Number 3, don't be afraid to try an issue multiple times. Different judge, better case law, different facts. All of these things can change the outcome of a trial from one case to the next. I've seen and heard so many attorneys say that issue doesn't work in this county, and that is just not true. That issue may not work in this county now is a better statement. You might have a county where there's not a lot of give by the local bench on null issues. You might have a county where there's not a lot of give on jurisdictional issues or on Kraft and Eldred type cases where driving is an issue. PC may not be the strongest in your particular jurisdiction, but again, don't generalize. If this thing is working somewhere, it can work anywhere. And even if it's not working anywhere, it could work somewhere in the future, depending on the makeup of the bench, depending on the way that future cases are handed down. Don't get locked into this position of this issue does not work. Maybe it didn't work in front of this specific district court judge, but it does work in Superior Court. And in Superior Court, you have multiple judges coming from multiple jurisdictions on a regular basis. So the issue that didn't work in district court in front of a district court judge that you've been in front of hundreds of times in the past on may very well work in superior court in front of a superior court judge, whether that's from your own district or that is traveling, visiting from a different superior court district. Case law changes, different facts. There's so many times that I have argued, PC in front of, a judge that I've done it, 10, 20 times in front of. And again, sometimes it's just unpredictable. How is all of the evidence going to play out? What is the judge going to hold on to? And so there's been times when I'm like, I feel like I know that this judge is going to grant my PC motion and it gets denied. Other times where it's like, man, that evidence didn't come out the way that I was expecting. And even though I've been in front of this judge a bunch of times and felt good about going into it, that didn't go well. It's going to be denied and then it's granted. So every case is its own. Don't get locked into this mental stranglehold of this issue doesn't work. Present the issue, be articulate about it, research it, dig and dive deep into it. If you want to win on an issue, go to war on it. Don't just throw it up as this half-hearted, half-researched, idea with no support or case law to back you up. Of course, the judge is going to deny that. It's not that the issue is bad, your prep sucks. That's the difference. Go at the issue hard and then don't get frustrated if it isn't granted. Keep fighting away on the issue. If it's a good issue to present, don't let it go. Keep after it, keep attacking. All right, and last here is always learn. This is the place of the way. This is the dojo. This is the training ground. The courtroom is the ultimate training ground. Now, after you get through a grueling trial, after you have put on the gloves and your face is beat up, you got your nose busted and you're, out of breath and you feel just beaten down, don't just turn around and walk towards the door because the match isn't over. You didn't get any feedback. You don't know why you lost or won, if that's the case. Don't leave that courtroom without feedback. Ask the people in the courtroom what you could have done better. Ask the prosecutor, what could I have done differently in this case? Ask the judge, what's one thing that you would say I could do to improve on this issue in the future? What was something that you felt like I could have done differently? What could I have presented? How could I have presented this issue in a way that was more compelling, that made more sense? Ask for that feedback. And again, whether or not you incorporate that into your next trial, maybe you have to go back to the office and reflect upon it before you decide one way or the other. But get the feedback. Ask the bailiff, ask the clerks, ask other defense lawyers in the courtroom, ask for feedback about your case. That's how you get better. That's how you improve, is through that feedback. And then go incorporate that feedback to the extent that it's helpful into your next trial and do it again. And incorporate it in the next trial and do it again. That's how you get better at it. That's how you become the man in the arena, the woman in the arena. It's to keep dusting yourself off, learn from your mistakes, try to do better, and step back in to the arena, step back into the courtroom, step back in to the ultimate dojo. Look forward to speaking with you again next time.